How's it going out there, you great funk fans? I'm back again. It's Professor Phil in the building. Yeah, I mean, got to love this game. Now check this out. All right, we're gonna go into something real simple. It's all about immigration bonding. All right, immigration bonding is the principle of something relatively simple, which
It's
is
5 o'clock.
it is 5 o'clock. So to ensure what you think is the abundance of your unalienable rights when you're an alien to a government that is an entity foreign to itself, and the only way it can recognize you is being that you are a foreign entity transcribed by its own laws. That's why they call them bylaws, sort of like, what do you want to call it, a byproduct, or what is another name, a good name for it, a by an in-law, just like a bylaw, an in-law, someone that is transcribed into your life as a prescription to the laws in which you are exhibiting between you and the agent or person or place or thing that is an abstract to this government entity that we believe we're not under. We just happily believe that it's a dynastic of our extension of behavior. We think that this is part of the way we are supposed to transition so that the Homo sapien ideology will become ours and we can perfect it in this world of grievances. All right, so here it is right here. The bond is posted as security for performance and fulfillment of the bond alien's obligations to the government. Government first, always government first, and most important, government first. This is, of course, excuse me, the Department of Homeland Security, U.S. Immigrations and Customs Enforcement. If you were to act as a sovereign or foreign entity, a more a specimen of life of any kind that would create a disposition in which the Immigrations Act, the Immigration and Nationality Act would be infringed upon, then one has to fulfill an obligation in order to come from under all the obligations of government who supplies you with the benefits you claim you do not receive, which of course them as sureties, I'm guaranteeing that they offer you everything in exchange of your guarantee to act as they say. You're bonded and you're supposed to fulfill an act, which is any statutory provision that they created so that you can live a much quieter and simpler life form. All right. An acceptable surety company or entity or individual who deposits United States bonds, notes, or cash may execute the bond as surety. All right. And this means, and by the way, I still got my logo up here, PNM, Politics and Money Incorporated, which is www.politicsandmoney.inc.com. It's a wonderful little link there. Well, it's actually not a link at all. I haven't mustered the time to get around such things. But the surety is the obligor, the bond alien is the principal. Okay, relatively simple. And you know that if someone brings a case against you, you are the principal. They are the surety who underwrites as the obligor, who obliges you to follow the principles and the rules of law and all the manifested language that goes along with it. And DHS is the beneficiary of all bonds it authorizes. The obligor guarantees the performance of the conditions of the bond, not the surety, the bond. Okay, so as surety, technically they take a step back and breathe relatively easy because that's the buffer between the liability party who can create a liability from acting outside of the surety's obligations that are conditioned within the bond, and thus the beneficiarial foreclosure upon the body so that the forfeiture of any benefits that come from your abstract living can be supplied as demanded back to the source that gave you the authorization to be uh, human, given an opportunity, given chances to fund and underwrite and guarantee the living conditions and just the abundance of providing for family and your loved ones and things of this nature. Great, right? Okay, since they're all in your life now, let's go on to the bonds guarantor here. Let's go from here. Okay, the bonds guaranteed is secured by the amount of the bond. An acceptable surety company um, is one of the appears on the current Treasury Department Circular 570 as the a company holding uh, um, the requested. Oh my God, my eyes! What is wrong with me here? This M is just messing me up. Certificate of authority to act as surety. It's kind of faded, but I'm trying to make it so that you can see it. I apparently am having a hard time here. I don't know why. Certificate of authority to act as a surety on federal bonds. This means that if the federal government has a bond against you, you can go and look up the circular companies, which are the Treasury Circular, I'm sorry, Treasury's Department of Circular 570, which is probably the listing. I'll go in, I might even pull the listing up for you. Or I'll just put it into this, I'll put this into this this actual I'll put the link into the body of this recording. An agent, let's see here, the most important part. An agent of an acceptable surety company may execute the bond only if the agent attaches to the bond a currently valid power of attorney showing the authority of the agent to act for the surety company. Powers of attorney do not have the official numbers, form numbers, I'm sorry. Now let's go all the way down here and we're going to see the authority and purpose. This is the reason why they claim they need it, which is more likely for internal revenue purposes, and that is to grant the specimen, the entity, to transcribe its rule and its principles over man in an artificial sense. What is wrong with this thing? Gosh. Yeah, here we go. All right. Give me 1 second. All right. The Immigration and Nationality Act, as amended, and has authorized the collections of information to provide. Let's see here. Okay, to provide for posting, maintenance, cancellation, and breach of any immigration surety bond and associated financial management activities, including collections of unpaid monies, such as child support, reimbursement of bond principal, which is any monies that they spent on it in which they had lost money on the principal themselves, and the calculation, payment, and reporting of interest. The Internal Revenue Code, in an executive order, authorized the collections of the Social Security number, which is exactly what they need in order for the bond to lapse once you are granted citizenship. Because once you get your papers and you get the official Social Security number, which then, remember, you don't get your ID first. You get your Social Security number, and well, actually, you would do your pledge. Your pledge would be the waiver of the bond, which you just basically gave the interest back to the United States, and then the Immigration and Nationality Act, which transformed the Social Security number into the new surety, which you can say it's like an IRA. They turn the IRA into a CD. So now you have a CD, which basically is the pledgerized substance. Okay, a CD is a certificate of deposit. So your certificate of deposit, all your papers that are filed, certificates that is, with a depository to act in the interest of any payments, calculation, or bond principal that you are given for the near future, so that you can put into the Social Security numbers account receivable payable to the Social Security Administration monies that you will receive to ensure your retirement or the benefits thereof for future consumption of U.S. Treasury notes for the purpose of living. Okay. Well, we got disclosure, which is not necessary. You can read that. It's relatively simple. Routine uses, usually for the Department of Justice and most common purposes. Public reporting burden, which is usually on you, not them. That's why they say that it should take no less than 30 minutes per application. Terms, conditions, and pretty much as you can see here, here's the most important part of some of why they need this particular document or the bond itself incurring in debt. Demands for amounts due under the terms of this bond will be sent to the obligor and the co-obligor after a declaration of breach becomes administratively final. For bonds posted by acceptable surety companies, if the surety company or agent of the surety company does not make payment within 120 days, a demand for payment, DHS may notify the Department of Treasury of such non-payment. If the payment is not made within 30 days of the date of the demand for the payment of interest, penalty, and handling charges as provided by the Debt Collections Act and the Federal Claims Collection Standard, will occur with the date of the first demand, which is basically any monies that they lose, they will go after the bond company for lapse of such surety, which basically holds no value and would like to, of course, the federal government would like to liquidate them for that particular purpose. And you see here, you got your power of attorney, okay, which allows someone to act for you, bonded alien file, and then the bond receipt. Now you can get a bond. It's funny, you can get a bond without necessarily having to be under the Immigrations Act itself, but if you want to act as a third party, recommending that you need a surety between you and the United States to benefit from them establishing a claim against you, those principles would be on the basis of acting in a foreign territory in which you would like to pledgerize yourself to the country only under the conditions that the agent would hold you harmless to the United States if in due time some type of grievance or discrepancy for financial goods, services, exchanges, criminal, civil, any type of disputes that may come or be occurred, that a financial obligation is set in place between you and the entity. Because if you're not separated from this entity, the entity transcribes that even just notifying them on the principle that you waive certain rights or benefits does not give them absolute power over your financial hood, over any guarantees that you may have in the future, or any freedoms which you can relinquish without posting an abstract obligation in order to keep the obligor's business from acting as a principal of your business. All right, so separating yourself is relatively, I'm not going to say difficult, but you have to have certain prerequisited established forms of accountability in charge of certain aspects of financial transactions that the United States, the states, and anybody else that makes a claim is going to come after you for, which is the most important aspect of being an immigrant in any country, is that you have a buffer. Okay, if I have an agent or I have a social worker, I have a subsidiary acting on my behalf, whether I'm imported or whether or not I'm deported for the purpose of national gains, taxes, or allocations for monies I haven't paid for, or yet I have not paid another country for, that I'm outstanding in that obligation to be instructed to pay, whether it's at their administrative settings, their legal departments, or whatever, however the setting happens to be, in whatever nation I happen to have the debt or credit, or for that matter, the lapse of any established accreditation between me and the entity. The entity is basically got its foot in the door to say anything that I would complain about would be an absolute waiver in the doorway, such as the the Nationality Act in and of itself. So the Immigration Act, or the Immigration and Nationality Act, basically in the doorway, if not waived, and as consumed before in my last video about immigration, the basis of it has only two substances that's most important. And one is that once you are established, that means that someone if the government recognizes you, as I said in my last video, oh gosh, what is this here? The Immigration and Nationality Act, appropriations and money. This basically, if you look very closely at the laws that they're transcribing, they're saying that if at $595, that deposit that you gave them as credit to act for you as a citizen, you pretty much you've granted them the allowance to act on your behalf. Once they've done that, they pretty much, upon that waiver, which is the deposit for monies that they did not have to pay, they say it's not a burden to you. they pretty much established that you, under the Nationality Act, in which if you waive, you have not signed it, that you cannot benefit from it, and if you have not signed it, you waive the right to privatization from it. And unless you have a judge that's co-signed that you are an immigrant or an established foreign resident, or you're a foreign alien, to the domestic disputes that they claim that they have against you, until you have that well established, then pretty much you're a debtor to a country without any credit, without any financial instrumentalism between you and the entity, and you have ensured that they, once they've accrued the balance of negotiating with you, will find you harmful to the abstract language that they use in their statutes. That's why some people actually get body slammed in such a way that would probably be criminal in and of itself, like 100 years for firing a firearm, and it's your first offense. I mean, these are the type of things that happens when you go in asking to be localized as foreign in your jurisdiction, but yet and still, when you say American or you attach anything that is abstract to the American language that interprets the legal language, such as Mexican American, Moorish American, a sovereign American, or for that matter, a sovereign with the capacity of a foreign national, you have to show that you have not only perfected such a claim, but your claim is superseding that of their claim, which is perfected on the principle of creating money out of thin air, ensuring that the Immigration and Naturalization Act, along with along with the Homeland Security's a principle, which is the Immigration and Nationality Act. These principles are the basis of how they create the principle of executing contracts. If you don't have one established, you do not have one in which you have been indebted to, in which you are attempting to accredit, or you don't have one accredited to you in which you can restore the balance of what they would indebt you to in the near future, then you are in serious trouble, my friend. All right? And as you can see here, excuse me, there's a lot of, it's just a lot of, I guess, infamous language. It's kind of cute here, sure. So a few things that logically would put one into a taxpayer bracket, sure. But ultimately, if you're not acting as an entity, then your sole proprietorship as yourself being that of being incorporated by the surety companies, the financial industries, the federal and state governments, then you pretty much are without any established standing whatsoever. Okay, in any way, shape, form, or fashion, that is. Okay, here's the last of it, as you'll see at the bottom. Okay, 31 USC A, subsection 7701. The head of each federal agency required each person doing business with that agency to furnish to that agency such person's taxpayer identifying number. Okay, it is the intent of the DHS to use such numbers for the purpose of collecting and reporting information on any delinquent accounts arising for each person's relationship with the government. The obligor, surety, or agent must furnish its tax identification. Now you see it says furnish its. That means not man or woman. They're talking about an entity. Taxpayer's identification number to DHS. Failure to furnish 10 of the 10 may result in refusal of bond. Okay? They're not just talking about you. They're talking about the person that could be held responsible for the debt as well. So both the field officer and the director here, who is administering this particular bond, which of course you just sign a waiver form and they sign everything for you, failure to apprehensively give the legal standing as established by this particular statute, the heads of this any of these federal agencies that are required to file a bond, who's basically doing business for the United States, knows that it has to ensure no hypothecating of rights are given without any just compensation. That is, they have to receive something of a benefit to ensure your Immigration and Nationality Act proceeds, that of the government's gain, is absolutely your form of diluted freedom, because at some point some contract's going to come along and snag you and you're going to go to jail or something. Something's going to happen, because it does, because anybody alien to a domestic a company known as the United States of America, even the domestic decals products, such as nationalistic people, common folks, especially ones that just have no clue that there's a world out there that happen to have generation after generation of people that have been established here, some practically for hundreds of years, have never known that this government entity was flashing its capital as part of its indigenous process to eliminate human nature and evolve it into a corporate a corporate type of caucus that we've unfortunately unwittingly slipped ourselves into. Okay, so here it is: the bond condition to be delivered upon any alien. In the consideration of granting the application of the above alien for release from custody under a warrant of arrest issued by the Attorney General, charging that he or she is, now you see that, he or she is unlawful in the United States, provided there is a furnished a suitable bond as authorized by Section 236 and or Section 241 of the Immigration and Nationality Act. The obligor hereby furnishes such bond with the following conditions. Now, the great part is they're talking about an immigration bond that they can fill out and thus would fall under the Attorney General. Okay, so you can ask, yeah, you can actually ask the Attorney General to file a conditional bond against you under the Immigrations Nationality Act for the purpose of acting as a national, and the extension of acting outside of the country's decal for the purpose of foreign and domestic relations. Okay, just like uh, this this thing called what's it called again? Uh, the peace treaty that was supposedly was established by the Arabs in Morocco. For instance, if you're going to use domestic relations with that particular document, has to be recognized domestically, not by the federal or the state governments, not even by the constituents extended from the allodial entitlement that's granted by these supposed politicians. It has to be recognized on a public record in which it will correspond. That means that, like, you send a beacon out and you hear the beacon on the other end, and it corresponds the same signal, the voice. When it comes down to the frequency, you have to hear the same. If I say something to you sounds good, you correspond the same thing, and it sounds good to me. That's called a corresponse. That's how you know you're in a relationship with someone, is when they correspond with you. Beacons. You send out a signal, you receive a signal. If you don't receive a signal, apparently you're not echoing. And if you're not echoing, you are not recognized by the thing in which is attempting to fire a missile at you, because that's just the way they do business. Okay? So here we are. It says pledged and power of attorney to use when United States bonds or notes are deposited as security. You can read on with that. It's great information. And then, of course, at the bottom here, pledged and power of attorney for use when cash deposit as security. I hereby pledge the amount of in dollars, United States currency as security for the purpose of fulfillment of obligations prescribed in paragraph C above. I appoint the Attorney General of the United States as my attorney to collect and to assign and transfer the sum of money. Now, the great part is this can be transformed. This appointing of the Attorney General means that any appropriations foreignly can be brought to domestic land for the exchanges and the purpose of using foreign language, foreign linguistics, for financial instrumentalism, and exchanges in which you may, right now, comprehensively, that would be if you walked into a courtroom, you would know how to do exchanges at the current rate for foreign purposes on domestic land, and for domestic purposes for foreign acknowledgement and foreign currency, and thus exchanges would prelude anybody's interference into an agreement between you and the entity. And that is any of these entities that are transcribing themselves out of language that are interpreted by statute or by law. So Attorney General falls under a statute. That is an entity prescribed by law. That is not a person. That is not a real thing. It is an artificial idea prescribed to a person in which was given a title. Okay? I agree that in case of defaults in the performance of any of the conditions hereof to which I subscribe, said attorney shall have full power to collect said money, said sum money of any part thereof, or assigned and transferred said money or any part thereof, deemed appropriate by said attorney to satisfaction of the damages, demands, or deficiencies arising by reason of such default. Now remember this: if you don't, if the attorney general won't do it, you can actually assign your own attorney general, which is a whole nother practice and principle in and of itself. But it can be done. It just simply has to be recognized by the very thing you are trying to escape, and thus allodial yourself the entitlement of what you title yourself. As you know, there's money in politics. There's Professor Phil in the bill. Oh my God! Wait a minute. Oh, all right, I'm back in the bill. Hey, so you can catch me at 424-245-9408, or you can email me at Philip Gillen, PhilipGillon, the number one, not the word, the number one, at iCloud.com. Questions, you shall be answered. I'm out.